This is Michael Popok, Legal AF. You may have learned in geography, Michigan is not Colorado. And the rules of Michigan related to who gets to be on the presidential and primary ballot are different than the rules in Colorado about the Secretary of State there and her role in trying to determine who gets to be on the ballot or not. Why does this matter? Because states are struggling state by state. We're watching. It's almost open warfare about whether Donald Trump's actions in his rejection of his constitutional duties to surrender power and peacefully transition, whether that constitutes a disqualifying disability under the 14th Amendment of our Constitution. And in the looking at the unique statutory scheme and the role of the Secretary of State in Colorado, the answer to that was yes. And he's been barred or banned, subject to an appeal at the U.S. Supreme Court to be filed by January 4th. Michigan, at around the same time, had a lot of issues coming up to the Michigan court system through trial court level, through what they call the Court of Claims, through the Court of Appeals, and now the Michigan Supreme Court about whether under the unique statutory scheme of Michigan, there can be anything done about it at the Secretary of State level to bar or ban Donald Trump from the ballot. Now, it didn't get into the intricacies of the fact-finding that happened in Colorado because Michigan didn't have a trial that way. It's always been through an appellate process, an appeal process, which doesn't develop facts that way. In Colorado, after a week long of testimony, there were facts that established that Donald Trump engaged in insurrection or rebellion against the Constitution. In Michigan, they're looking at a more arcane issue, a more narrow procedural statutory issue as to whether the Secretary of State of Michigan has the power under unique Michigan law to bar or ban anybody that she believes, or it's proven to her, is not qualified. In other words, can a party like the Republican Party put a non-qualified person on the ballot and the Secretary of State can't do a darn thing about it in Michigan? And the answer to that question appears to be, and is in Michigan at least, yes. If the party in Michigan, the Republican Party, wants to put Donald Trump in jail, while he's in jail or while he's disqualified or under the 14th Amendment, and they want to run him for office, the Secretary of State can't do a darn thing about it the way the courts of appeal up to the Supreme Court in Michigan have ruled on that issue. And that may come as a little bit of a shock. Let me try to reconcile Colorado versus Michigan and then talk about the U.S. Supreme Court decision that's looming out there, right? Like a big radioactive red letter date as soon as Donald Trump files his appeal that he has to file under Colorado's ruling by January the 4th. And what the issues there will be and what they will not be and how they will then back up against the decisions in Colorado and in Michigan. Michigan's, a number of their Supreme Court justices in the majority and at the different levels of appeal have all looked at the issue and said, basically, we may not like it, but our Secretary of State doesn't have the power to either require somebody a test that they are qualified to stand for office as a condition of putting them on the ballot. Instead, their process is different. It's the Secretary of State takes a look at the media, right? And does like a media survey to determine who's the leading candidate. And then the party in the primary system tells the Secretary of State who is their candidate, qualified or not. And that gets printed on the ballot. And there's no other way around it. And there's no other administrative or technical requirement that needs to be satisfied or process that needs to be qualified. Now, separately, at the intermediate appellate level in Michigan, the original judge that ruled on the issue, who's now been affirmed through the Michigan Supreme Court, and I'll explain that in a minute, Judge, and wait for the name, Robert Redford, not that one. Judge Robert Redford went through an entire analysis, and he eventually concluded not only did the Secretary of State not have the authority under the statute in Michigan to deny somebody a place on the ballot that's been properly chosen by that party, that's a party issue, a political issue that they should stay away from. He went further, and what we call dicta. It's not the gravamen of the ruling. It's not the basis of the ruling, but he goes on in dicta to talk about, well, it's also a political question. I don't think anything under the 14th Amendment, Section 3, should be decided by the courts. I think that has to be decided by Congress. This is the argument Donald Trump has been making. right? You can't, it's not that I'm not an insurrectionist or I didn't engage in insurrection or rebellion. It's that you can't get me here in courthouses. You got to go to the Congress. I control Congress right now, at least the House side. And they have to go through a process. Now, every constitutional scholar, Republican, right-wing, Federalist Society, every one of them, worth their salt, have come out and said that the 14th Amendment, Section 3, is self-effectuating. You don't need to go back to Congress. Congress already declared, without any reference to any other process, as long as somebody is found to have been engaged in insurrection or rebellion and taken an oath of office to support or defend or protect the Constitution, they're out of office. This was done during the Reconstruction period after the American Civil War to deal with what do we do with the Confederate leaders, including Jefferson Davis, who went off to become the president of the Confederacy when they want to come back and run for office in the Union. Sure, we want to make the Union whole again, but doesn't mean we want all the rebels and all the people that ripped up their oath to support Abraham Lincoln and the Constitution back in government. And so these were a series of loyalty tests that were in many, many laws, including here embedded in the 14th Amendment, which was passed after the Civil War during the Reconstruction period to set up just this type of loyalty hurdle to come back into the government. Now, it's applied to things other than the Civil War, obviously, and now being applied to Donald Trump. So there's no mention in the legislative history around the 14th Amendment or the 14th Amendment itself that says, oh, there's another step. You got to go to a courtroom and get a conviction against that insurrectionist on an insurrection charge, and then come back and then Congress will take him out. It doesn't say that. And so it's been interpreted by the Colorado Supreme Court and many other courts and many other legal scholars to mean what it says, self-actuating. If it's proven, and generally you prove things in courtrooms, and that's what judges get paid to do, then it automatically disqualifies the person from being on the ballot. Michigan, different issue. So what the Michigan Supreme Court has done in the reporting here, it's a little bit murky. Let me shine a bright light on it. The Michigan Supreme Court did not issue an order today affirming Donald Trump's right to be on the ballot. They refused, in a one-paragraph decision that wasn't signed by any of them, they refused to accept the appeal from the lower-level appellate court that ruled in Donald Trump's favor. Now, there was a dissenter. There was somebody who wrote a 4-page dissent, not to be confused with the majority opinion, because there is no majority opinion. But Judge Welch wrote that if it was in that judge's purview, that they would have taken the appeal and they would have made it clear that when the lower court appellate judge went into the area of political question to make a ruling or a finding or a pronouncement, that also this should never be handled by the court system at all. It should always be a political question. That was dicta. That's not the heart of the case, and that should be ignored. He would have taken it, or that judge would have taken it for that reason. That's it. But if you just look at the actual order, it's just here, the top paragraph, and it just says effectively in legal terms, we're not taking the appeal. The lower level ruling stands, which ultimately goes back to Judge Robert Redford's original ruling. Why does this matter? It matters because states are struggling, and we're reporting on it, on how to map constitutional provisions, criminal laws on the books over and on to Donald Trump's conduct. That's what we're watching. The struggle of the court system, the judicial process, to restrain and contain Donald Trump. Same thing will happen if, God forbid, he gets reelected. Now, what is the U.S. Supreme Court going to say about all this? And how does it impact Michigan and Colorado? The issue that's going to go up on appeal to the Supreme Court on the 4th of January is going to be multi-pronged. It'll be Donald Trump arguing that this should never be in the court system. This is a political question reserved for Congress, thumbs up or thumbs down. So sort of the issue that is in the dicta of the Michigan decision will be front and center at the appellate level. They'll have to decide that broader issue, right? Are we properly in the court system, or is this something, even if it happens, that has to be tried, if you will, in Congress, like an impeachment process with the House and the Senate involved? Yes or no? Because if it's a political question, the political question doctrine takes the case out of the court system and puts it back into the legislative branch, into Congress. That's fundamentally one. And if they rule that, game over. Game over for all of these challenges, because then no court system, I would posit even Colorado, and its unique statutory laws would survive that analysis, because it would never get into the court system to have a court declare anything about the role of the Secretary of State if it's a political question ultimately about whether the president is qualified, the candidate is qualified or not to be on the ballot. Qualified meaning big Q qualified under the 14th Amendment. If the issues of qualifications and electors and all the issues about the presidency are only in the Congress, then the declaration of the United States Supreme Court could be that there is no role for the court system, the judiciary. They should stay out of it and leave it to the Congress, which is ultimately being left to the voters to make the ultimate decision. And that's may be where they go. And that will kill all of these decisions. Even I suggest the one in Colorado, where they have a unique statute that says the Secretary of State can make her own ruling. She can't make her own ruling if the Supreme Court says you shouldn't have been making that ruling anyway because of the underlying facts that were developed in a courthouse, should never have been in a courthouse, and you should not have had that information when you made your decision. So there'll be a whole fight about that. So I do believe, I know there's some commentators who say there's no impact on Colorado if Supreme Court, because of what just happened in Michigan. I don't believe that's true. So that's one way, one exit ramp for the Supreme Court to make their ruling. They could make the other way. They can make the ruling that Article 3 of the 14th Amendment is self-effectuating, and does not need a role of Congress, because Congress's legislative history doesn't say it does, and the language of the statute of the amendment doesn't say it does, and therefore courts are what has been put on this earth to develop facts and apply the law, and therefore the courts in different states can do whatever they want depending upon their own statutory requirements about the electoral and presidential process, because states play a role in that. That could be their ruling. But I don't think the Supreme Court ignores it completely and makes some sort of, we don't have standing to hear this, we don't have jurisdiction to hear this. They're going to make this ruling once and for all about the 14th Amendment, Section 3. And then how, as a waterfall, it gets applied through the various unique statutes within each state. And we'll continue to follow that and what happens off the briefing, because we think this is going to go very fast at Legal AF at the U.S. Supreme Court. January 4th, there's going to be the appeal that's filed. I don't think it's just a notice of appeal. I think it's the full papers. And if he doesn't do the full papers, Donald Trump, and tries to play games with the filing and tries to delay things, I think that'll just lead, he'll be off the ballot in Colorado, because they're giving him time to appeal, which means that Donald Trump is going to have to ask for a stay at the United States Supreme Court level of the Colorado decision to step in for the administrative temporary stay that the Colorado Supreme Court has put in place. It's going to have to be replaced by a U.S. Supreme Court stay, or the stay is going to be lifted in Colorado, and Trump's not going to be on the March ballot. So there's going to have to be at least 5 votes to stay the case. First, it's going to go through, in Colorado, Judge Gorsuch. Judge Gorsuch, who's the Supreme Court justice assigned to the 10th Circuit, which is where Colorado sits. And so he's going to have to decide first, either himself on a shadow docket basis, or refer it over to the full 9 of the U.S. Supreme Court, which I think he will do. And they're going to have to decide whether they're going to temporarily stay and then add to it an immediate briefing schedule. Because I think they understand that they need to brief this quickly because of March's primary ballot issue. And that timing may be enough for them to stay it, do full briefing, and then make this decision fundamentally that I just described about the application of the 14th Amendment and who gets to decide within the various branches of our government, the executive, the legislative branch, or the judicial branch, or is it a political question? We'll continue to follow things about political question and items at the intersection of law, politics, and justice on Legal AF, that podcast that we do on Wednesdays and Saturdays at 8 p.m. on the MeidasTouch Network. Free subscribe. Help this independent media network without outside investors reach 2 million free subscribers, and do it right now if you can. And then follow us not only on our YouTube, Legal AF, but on audio podcast platforms of your choice. Give me a thumbs up if you like this kind of content. Keeps me on the air. But until my next Legal AF, until my next hot take, This is Michael Popok reporting.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.